Morning, everybody. Nate Eaton here in the EastIdahoNews.com newsroom. We've got our entire team here working today. This is a fairly significant day in the Chad Daybell case because we could learn as soon as today whether the trial will be moved from Fremont County, Idaho, where Chad is charged, to another part of the state. It's also possible that the judge might not rule today, or that there could be a partial change of venue. Let me just set the stage for you. So when Chad Daybell was charged with several crimes, including first-degree murder for the deaths of Lori Vallow, Tylee Ryan, Chad's first wife, Tammy Daybell, back in June, when the grand jury came back with the indictments, the prosecutor, his attorney, John Pryor, asked that the trial be moved from Fremont County to another part of the state. He argues that because it's such a small area that a fair and impartial jury cannot be found, and that is what will happen today. That he will go forth before Judge Stephen Boyce in Fremont County, and he will argue that the trial needs to be moved. Now, we do know that the prosecutors, as recent as last week, have said, all right, we agree that there might need to be a change of venue, but they want a jury from another part of the state to be brought in and sequestered in Fremont County. I've been here for several years. I covered news here several years ago. I don't recall a sequestered jury ever being brought in, or be a sequestered jury trial ever being held here. One of the most famous trials, O.J. Simpson, his jury was sequestered. You don't hear about it a lot because it is expensive. It can be taxing on the system. And for a trial that could be 5, 6, 7, 8 weeks long, as the Chad Daybell trial could be, that's a lot of time that this jury has to be sequestered. So today, John Pryor will present his argument on why he thinks this trial needs to be moved out of Fremont County. It could go anywhere in the state of Idaho. Several people have asked me, well, could it get moved to California or another part of the country? Nope, it has to be held in Idaho. It could go to Boise. It could go to Pocatello. It could go to Idaho Falls, which is only about 40 minutes south of where St. Anthony is. But really, the purpose is, for John Pryor's purpose, is to find people who he believes will be fair and impartial. Now, does that mean that the jurors have been living under a rock and haven't heard about this case? That's not what it means. What it means is you could have heard about the case, but you have to be willing to say, but I'm open-minded. I can be fair and impartial as a juror and say, okay, well, yeah, maybe I'll be open-minded to this. It's not like you haven't, you can say that you've heard about the case. You just can't say, yeah, my mind's already made up. He's guilty or he's innocent. The defense is going to, I'm getting the time. Volume on my phone. Is it feeding back? That might be Andrea's phone. And it's my phone. Sorry if you're getting feedback on there. By the way, if you're watching and you have questions, shoot them to me and I'll do the best I can. We're just going to talk here until the trial starts. Until the hearing starts. It's about 7 minutes away. We have viewers in the UK where it's 3:52 p.m. We have people here watching from all over the place, 4:51 in one part of the UK. Of course, we all know that this trial, this hearing, this case has gotten attention worldwide. Now, what's going to be discussed today, we'll be transparent and honest with you. Both sides, the prosecution and the defense, have requested a lot of data from EastIdahoNews.com. You might remember months ago that I was served with a subpoena from John Pryor. He wanted me to testify during this hearing today. We believe that journalists should not be involved in trials, in cases of this magnitude or any case at all. Our job is to really represent you, to sit on the sidelines and observe. The minute we're brought into a trial for either side, it can become pretty messy. I will not be testifying today, obviously, but what we did is at East Idaho News, with the advice of our attorneys, is we said, we don't want to be a witness, but what are you looking for? And Chad Daybell's attorney, John Pryor, asked for data. He asked for how many stories we've published over the past year and a half. How many videos, how many photos, how many Facebook posts. All of that information he asked for, which he will obviously try to use to say, this is the reach of East Idaho News, and this is why he will argue that there's been so much media coverage that we can't find a fair and impartial jury. The prosecution has also asked for our data, similar data, how many page views and how many viewers we have in each of the counties and cities and whatnot, and we provided both teams, both sides, along with Lori Vallow's attorney. We provided them that information. We also published that on eastidahonews.com, and we can put a link in the comments if you're interested in seeing that story that we did. Boy, that was probably back in May. It's been a while. So I have no doubt that our coverage may be discussed today during the hearing, and other media coverage too. It was not just us that was approached. We know that. We know that other media in the state was approached, and so the reasoning behind that is that the prosecution might say, well, East Idaho News coverage and other media coverage is statewide. You're not going to go anywhere and find a fair and impartial jury. While the defense might say, look at these specific areas. There was a ton of coverage here. It will be harder to find a fair and impartial jury. We know that witnesses will be called today. In fact, the prosecution is going to call Chief Shane Turman. He is the Rexburg Police Chief, along with Sheriff Len Humphreys. He is the sheriff in Fremont County. John Pryor plans to call Ironwood Insights, somebody from that firm. Eric, was this the firm that did the survey? This was a firm that did a survey months ago in Fremont County. From what we understand, they basically went around and talked to people in parking lots, on the street, saying, have you heard of the case? What are your thoughts on the case? And so this company, a representative from this company, will go and likely reveal the results of their surveys that they did on the street. So that should be interesting. Now, up until a week ago, this hearing was supposed to be held in person. We were all supposed to be at the courthouse. We know that Court TV was planning to come and broadcast this nationwide. We were planning to be there. There was going to be social distancing in the courtroom because of COVID-19, but this was going to be in person, and this is one of the reasons that the defense attorney wanted it in person. This hearing was set months ago, and then it got pushed back because the indictments came down against Chad and against Lori, and we know, of course, her case is on hold because she has not been found competent for trial. But this was supposed to be in person. Last minute change last week as COVID numbers went up here in Idaho. Judge Boyce decided to move this remote. So there won't actually be any convening in a courtroom. You'll see it'll be on Zoom, and we'll have it here live in just a few minutes. You'll see the Zoom boxes. The judge will be in one box, prosecution in another, John Pryor in another. I would imagine that this is a very rare time that a change of venue hearing is actually held on Zoom. Normally you try to do these in person because evidence could be presented, witnesses are called, so it's unclear where the police chief will be appearing from, maybe his office, or maybe he'll be there with the prosecution, but it will be a little different. It's just kind of nice to know that this hearing will finally be happening and that we could know today, or the judge really could rule at any time. He could wait a week to say, okay, I'll issue my ruling in writing, and here's where the trial will move. At least once we know if it will be moved, you can start planning for it. Now, these are heavy, heavy charges, multiple charges of murder, conspiracy to commit murder involving multiple victims. And so the trial was supposed to be this fall, I believe in about a month. It was originally supposed to be in November, October timeframe. Chad Daybell has waived his right to a fair and speedy trial. And so it's likely the trial will not happen at least for 6, 7, 8 months, maybe a year. So we're going to have another year of covering this. And the reason why it's so time-consuming, a lot of people say, well, can't we just, call a jury today and get it done? Well, this is a death penalty case. And so you really want to be sure that your arguments are strong if you're the prosecution. And if you're the defense attorney, you really got to have a strong defense. I'm told that Chad Daybell has a laptop that he has access to. It does not provide internet access, but he has a laptop that he can go into the library room at the jail and review evidence. And that's what he has been doing, terabytes of evidence. He spends his day at the laptop going through this evidence, seeing what the prosecution has on him, or the text messages, whatever you want to say, whatever evidence could be used at trial. Chad Daybell has been reviewing in order to assist his defense. There is not contact between him and Lori, as there shouldn't be between any two inmates, especially if there are conspiracy charges, meaning you conspired with somebody else. What's the condition of Lori? A lot of people are asking. Why isn't she on the docket today? Well, everything in Lori's case came to a halt, came to a stop once a medical professional deemed that she was incompetent to proceed. Judge Boyce agreed, and so she has been moved to a facility under the Department of Health and Welfare here in Idaho. It has not publicly been revealed where she is at, but that happened back in June. In fact, she was never arraigned on the new indictments that came down. Those new indictments were for murder, were for the conspiracy to commit murder, were the very, very serious charges. She never had her initial court appearance. Once those indictments came down, her attorney, Mark Means, filed for a motion that she was not competent. She was moved, and since then we have received a few updates from the Department of Health and Welfare where she still is not competent, and the question now is, should she be forced to be medicated? Based on the court documents we have reviewed, it sounds like the professionals believe that if she is medicated, she could be then competent for trial. The question is, can you force someone to take medication? And a lot of these hearings with Lori are held in chambers. They're closed to the public because the judge, they're basically held off the record. So there's likely some things happening behind the scenes. We do know that the judge did appoint co-counsel to Mark Means, who's been her attorney since the beginning, since this all broke out in, December or January of 2020. She now has an additional attorney, Jim Archibald, who is a public defender, who is a death penalty certified attorney. He has represented several high-profile clients in Idaho, including the latest was Brian Drips. Mr. Drips murdered Angie Dodge, murdered and raped her back in the mid-90s, and was tried for her crime after a long, I want to say crazy process. Chris Tapp went to prison for Angie's murder when he didn't commit it, and it turns out Mr. Drips did. Anyway, he entered a plea agreement and was sentenced just a few weeks ago. So Jim Archibald is an experienced defense attorney who has done these sort of hearings before, and he is now on the case assisting Mark Means in the case of Lori Vallow. So that's where Lori's case stands. Let me check my clock here. We're at 9:03. Any sign that this is happening? Let's cut. Can we cut to the court page just to show people? We are monitoring the court feed. So once it comes out, you can see right there. We're just waiting. Once the hearing starts, we're going to cut to it right away. I can promise you that. These hearings tend to be late. As you know, if you followed this, they tend to be delayed by a few minutes. And today is probably the most significant hearing that we have had in quite a while, at least since Chad and Lori were charged with these new charges. It was back in August, over a year ago, when Chad actually appeared for a preliminary hearing in Fremont County, and that we were under similar circumstances there, but we did have a camera in the courtroom that was able to record, and a very few people were allowed in. Kay and Larry Woodcock were there, as were a few others, but everybody else had to stay outside because of COVID precautions. And that was the preliminary hearing for his original charges, where the judge, and what a preliminary hearing is once you're charged, you have an initial court appearance within 24 to 48 hours. You legally have to go before a judge. The judge will read you the charges, and then you can, you don't plead guilty or not guilty, you're just informed of what you're charged with, and then a preliminary hearing is set. And a preliminary hearing is where the prosecutor basically has to prove to the court that they have enough evidence to charge you with a crime. And if it's a felony crime, your case then will advance from magistrate to district court. So what this means is the judge will say, yeah, there's enough here, we're going to advance the case up to district court. That's what that hearing was last August. And the judge did find that there was enough evidence there to advance Chad's case. Then all of these new charges came out back in June, and now we wait for this change of venue hearing. So that's where we're at today in the case. We've got all sorts of questions here. Are there any that you guys have spotted that I've missed?
Where is Mark Means?
Where is Mark Means? That's a good question. Mark Means has not been at the past few hearings. He will not be involved today at all. This is just Chad and his attorney, John Pryor. We're assuming Chad will be there. Obviously, he needs to be there. This is his case. If we were in a courtroom, you would see Chad there by his defense attorney, but he'll likely be sitting at the jail, and there'll be a video feed, and he'll be sitting with John Pryor, or he might just be on his own camera while John Pryor is at his office in Meridian. As for Mark Means, he has been gone the past few hearings. He is still on the case, as far as we know. I've reached out to him, and we've communicated briefly, and he has made no indication that he is off the case. But now that he has co-counsel, Jim Archibald has been showing up at those hearings, and Mark Means has not. There was the hearing that we carried last Thursday for you. If you missed it, you can go watch it on our YouTube channel, East Idaho News YouTube channel. It was a very last-minute hearing, I will say that, and Boise Meridian is about 4 or 5 hours away from Rexburg, so it can be a bit of time to get there, but you're right, he has been absent from the past few hearings. No indication, though, that he has left the case or anything. Any other questions?
Are they doing the trials together?
As of now, good question. As of now, the trials are still joined. Now, John Pryor has asked for them to be severed. And up to this point, the judge has not agreed to that. And the prosecution argues, well, the charges are so similar, the witnesses are so similar, they're probably going to be the same. Everything is basically the same. We might as well save taxpayer money. We might as well save time. We might as well do them together. And as of now, they're together. Now, if John Pryor, if they move the venue today, or they decide on the venue, or they keep it there, his case will obviously progress quicker than Lori Vallow's would. So there could come a point where they do sever them. It could be possible that Lori Vallow is not held competent, ever, or at least in the next year or so. Now, what does that mean? It doesn't mean she's off. She's scotch-free. She's free to go. What it means is she will remain in the facility where she's at and seek mental and psychological help until the point that they deem her competent. The charges are never dropped. There is no insanity defense in the state of Idaho, so she can't plead insane. What it does is it basically freezes everything until the day she is competent. I've talked with prosecutors who have said that this happens, I don't want to say routinely, but it does happen occasionally or regularly, and 98 to 99% of these people are eventually held competent. We did a story in Madison County a few years ago of a woman, Jessica Conser, who shot and killed her father. She was held incompetent. She went away to a facility, I believe it was for a year and a half, and then was held competent. And she was brought right back to Madison County, and a hearing was held, and she ended up, I believe she pleaded guilty in a plea agreement. I'll have to double check on that. But anyway, the case did progress. So it's not like Lori Vallow is scotch-free and she's ready to go do whatever she wants to do. She will still be in the facility. So as of now, yes, the trials are still together. They should still progress together. I can't imagine more, I don't want to say, it'd be interesting, I'll say this, it would be interesting to watch if Chad and Lori are together in a trial and they decide to turn on each other, or one decides to blame the other, and they're there in the courtroom together when all of it plays out. That would be an interesting dynamic to see. All right, any update on the trial, the hearing? They're still getting started, a lot of technical stuff, especially when you're bringing in multiple camera feeds, multiple Zoom feeds. But we're keeping an eye on it. We will keep you posted. What other questions do you all have? Any other questions? What's that? Oh, Arizona charges. All right. So right now, Chad is not facing any charges in Arizona. That could change down the line, but right now there's no charges for Chad. Do we have is it start? Not yet. We're getting close. Lori is facing charges in Arizona, but what Arizona authorities have done, and of course these charges are in connection to Charles Vallow's death, they've basically put them on hold in Arizona. They've basically said, we're going to let Idaho take care of the Idaho charges and the Idaho things. And then once Idaho gets all of them processed, Arizona will take it. Now, there's cases of are we here? Okay, we're going to cut.
Okay, you're ready to go. Okay, good morning, everyone. This is Fremont County case CR 22211623, State of Idaho versus Chad Daybell. This is the time set for some motions this morning. Representing the prosecution in this case is Rob Wood, Lindsey Blake, and Rachel Smith, who are appearing by Zoom. Representing the defendant, Mr. Daybell, is attorney John Pryor. Pursuant to the Idaho Supreme Court's most recent order regarding court operations during the COVID-19 pandemic, this court hearing is being conducted by Zoom. The proceedings being recorded on the Zoom software, also recorded on the FTR system of Fremont County, and also is being reported by the court reporter. In addition, in order to allow public access and help and allow for that access, the hearing's being live streamed on the court's YouTube channel this morning. So we've got motions. This was originally scheduled on a change of venue motion. In the interim, we've had other motions filed of late that I think need to be brought up first. I'll just go through the motions that I see are pending today. There was the change of venue motion that was filed by the defendant on July 21st. The state filed its response to that on September 29th. On September 29th, also the state filed a motion to sequester a jury and bring a jury in from another county for the case. On October 4th, Mr. Pryor filed a response to that motion and also a motion to continue the hearing on that motion. And I allowed for shortened time to hear the motion to continue. Also, there was a motion to seal the hearing today that was, I think, filed yesterday on October 4th. And that was under a request by the state to seal today's hearing. And so I think the first issue we need to bring up probably is the motion to seal the hearing, which was filed on September 30th. And I've reviewed the motion. I'll hear argument on the motion at this time. Ms. Blake, if you're the one that's going to be arguing that motion to seal.
Your Honor, I'll be arguing that motion.
All right, thank you, Mr. Wood.
We'd ask that this motion be heard, not in the public view, where we're discussing issues that might need to be sealed. We leave that to the discretion of the court, but we don't think this specific portion of the motion or hearing needs to be broadcasted.
All right, any response, Mr. Daybell? I'm sorry, Mr. Pryor. Yeah.
Mr. Daybell is judge for the record to my right today in the office. Judge, frankly, there's no reason to seal this hearing. I previously provided to the court, I believe just short of 8 o'clock this morning, not only a list which had previously been described of all my exhibits, but also the thumb drive containing all the exhibits, as well as the slides that I anticipate using as part of my venue. From my perspective, there's nothing objectionable, and I purposely obviously at a discussion with the
Your
court.
Honor, he's arguing not about whether or not we should, about the actual motion, not about whether or not this portion of the hearing should be not be live streamed.
Well, Judge, the point is that there's no reason to seal this. This idea that everything should be sealed because the prosecutor doesn't want it disseminated out in the public. The right to a fair trial and the right to everybody hearing the evidence and what's being alleged by both sides is particularly important. And I can't for the life of me understand why this prosecutor wants to stop the public from observing the reasons for this court to potentially change venue. Now, I understand.
Again, Your Honor, he's already arguing the motion. I haven't even had a chance to.
I'm not arguing the
Totally
motion.
inappropriate.
And
Well,
it's
I
not
understand.
inappropriate.
Counsel,
It's not inappropriate.
it's a fairly straightforward issue. And let me just indicate, part of the issue here is typically if we didn't have the COVID issues and the limited court operations as a result of that, we would be doing a hearing in person. And if we were doing a hearing in person, then we would be in open court. And then the question would be, are we going to be in open court or closed court? Because of the COVID restrictions we've got and an order we just had recently, which imposed further restrictions, the court determined that conducting this remote was in the best interest of complying with that Supreme Court order for this type of motion and hearing. On the Idaho Court Administrative Rule 32 does give the court some discretion to seal or close certain hearings or seal either close the hearings, seal the record of the proceedings, or both. The court has considered that in the context of this motion, and I do find that this is a hearing that typically would be open to the public. It does deal with some issues that could create further dissemination of the information we're talking about on the change of venue. But I think there are ways to do that that are less restrictive than simply closing the hearing and sealing the proceedings. That's kind of a remedy of last resort under Rule 32. And so I am going to deny the motion to seal this hearing. Part of the issue also is, well, what I'm going to do is, I do know there are potential exhibits and there may be some testimony that needs to go off the record. And that can be done in the context of, I'll give you an admonishing instruction that if we are going to get into information that's clearly inflammatory, that's clearly going to possibly create an unfair bias or prejudice to potential jurors in this case, then I'm going to admonish counsel not to just put those matters out there without giving me an opportunity or the other side an opportunity to object and determine whether or not that should go into a closed portion of the hearing where we can go still on the record, but outside of the live stream portion of the proceedings. The exhibits can be reviewed in camera. I'm going to instruct counsel, they're not going to be broadcast or live streamed, the particular exhibits that may be used in support or opposition to the motion. And so with those precautions in place, I don't think we rise to the level of needing to close the hearing and seal the proceedings under 32, because again, this is typically something that the public's entitled to see as an open hearing in a criminal proceeding. So with those admonishments in mind, counsel, we're going to go forward. This will be an open hearing. And if we do have matters that need to be taken up off the record, we can do that. And I have the ability to close that part of the hearing or seal that part of the proceedings. So that'll be my ruling on the motion to seal. Any questions on that ruling, Mr. Wood?
No, I would just note on the record that the state filed the motion. Mr. Pryor clearly argued that the state was not allowed to make any argument in favor of its motion. But we do understand, Your Honor. Thank you.
All right, thank you. Any questions on that, Mr. Pryor?
No questions, Judge. Thank you.
Okay. The next issue that I think we need to raise would be the motion to continue, because I know it'll get into the middle of that when we're doing the venue motion, but there was a motion the state filed to sequester, and there was a motion then to continue the hearing on that. So I want to be heard on that motion to continue the hearing on the state's motion, Mr. Pryor.
If I may, Judge.
Yes.
Judge, I took the liberty of spending the entire weekend putting together a brief on what I think are the pertinent points. I'm not going to belabor them. If the court looks at my reply, you will see there are a number of issues that come into play. My reading of the motion to sequester only occurs after the court has decided, one, whether there's a change of venue, and two, where that venue change occurs. At that point, the state's motion to sequester becomes ripe at that point. It's a premature motion. The other issue is this, Judge. If you read my reply, there are a significant number of financial factors that go into whether this court should sequester jurors for what is likely to be a 2-month trial and the cost of that. And before I know where the trial will be or the jurors would potentially come from, what county, I can't do a fair assessment financially. And it's completely unfair. Mr. Wood filed this on the 29th. 6 days later, I'm supposed to address a motion when, frankly, Judge, my venue motion has been sitting out there for 2 months, and Mr. Wood filed his response 6 days ago. So it's a little unfair, it's premature, and I think the arguments I made in my reply speak for themselves, Your Honor.
All right, thank you, Mr. Pryor. Response from the state on the motion to continue.
Thank you, Your Honor. I would note that the motion to sequester a jury is not dependent upon the outcome of a change of venue. The state will be asking and has asked for the jury to be sequestered no matter where we are. So whether the court today changes venue and we have this trial somewhere else, or transfers trial, I should say, whether the court decides to change venue and then bust the jury back, as the state has recommended, if the court feels that it's necessary, or whether the court decides that Mr. Pryor hasn't met his burden, because it is his burden today, and that the change of venue doesn't happen, we're going to be asking for a sequestered jury to the state. That's a sunk cost. So the costs that the state is concerned about and will be concerned about are the additional costs of changing venue. And that's why we've made the request that in the event the court, out of an abundance of caution, decides to transfer trial, that we bust them back. In terms of this unfairness issue, I'd note that Mr. Pryor keeps complaining about the lack of a brief or reply. He never filed a brief in support of his change in venue. I'd note that this binder of documents he's talking about was delivered to the Fremont County's office this morning. I don't know if we're supposed to print those off. I'm still waiting to get my copy of it, which I'm sure I will soon. But so this idea of unfairness, it's a little out of place. Your Honor, the issue of sequestering a jury does dovetail with change of venue, and it should be allowed to be heard today.
Judge, in reply, and I'll be very brief, Mr. Wood in his pleadings on the 29th, 2 months after I filed my change of venue, indicated that he's not objecting to a change of venue. So at this point,
Mr. Pryor, I disagree. I mean, there's some statements in there that, to avoid appeals, et cetera, they may agree to that. There's also a pretty clear statement in his pleading that they believe they can get a fair and impartial jury in Fremont County. So that's an issue, still needs to be determined at the change of venue motion. And I don't see that as a stipulation at this point. I mean, that we may get there, but I think we have to have that hearing first to determine what the state's position is on that issue.
Well, Judge, again, if the court's going to look at this in terms of financial factor, where exactly are we going to derive this sequestered jury from, and what county are we going to derive it from? And to give me, in reality, a couple of days to prepare the financial information to address this sequestering the jury is just blatantly unfair. I would point out in Mr. Wood's response when I delivered my notebook to everybody, I had delivered several weeks ago the same items on a thumb drive. I hand delivered it to Ms. Blake, and I hand delivered it to the court, and it's the same documents with the exception of a couple of additional things that I just received as before. And the notebook I provided is in response to this court's direction to us that we are not to broadcast items that we find might be influencing how the jury and potential jury would look at this. So I'll explain the notebook and I'll explain, but all of the documents have been provided, and they were previously provided probably 6 weeks ago. So Mr. Woods, I don't appreciate the argument.
Well, all right, I'll go back on that point. Really, the argument kind of stemmed from something that you brought up at the prior hearing, Mr. Pryor, where you said that their late filing just before the status conference was some sort of gamesmanship, to which I disagree. I've dealt with both Ms. Blake and Mr. Wood on many occasions on many criminal cases, and don't find them to be prosecutors that are playing games in any sort. And I think that's what kind of started this line of personal insults to the attorneys back and forth. And I admonish both of you that just keep things professional here. I'm not sure what the late filing reason was. On the motion to sequester, I know that it was filed on the 29th of September. We're now on the 5th of October. According to Criminal Rule 45C, motions need to be filed at least 7 days before hearing. And so that's one reason I'm looking at to grant the motion to continue on the issue of sequestering a jury. But I think more importantly, going to the point of the substance of that motion, I think it is premature because the decision needs to be made as to venue. And that would actually, it's not technically change of venue, it's the transfer of the trial if that does happen. Where that would be and how that would be done is only going to be determined after we make the decision based on the pending motion today. So I still understand the state's request, and we may need a future hearing on that, or the court may be able to determine that from what's heard today. But in terms of a separate hearing on sequestering the jury, I think it is premature. The other factor I'm looking at is the fact that we don't even currently have trial scheduled in the case because we need to get through this venue motion. And so for those reasons, I am going to grant the motion to continue on the sequestration issue. That motion then will be kept under advisement until such time as it can be heard at a future date. So that'll be the ruling on that. So council, that'll bring us up then to the motion we're here for today, which is the motion filed on July 21st, which is filed as a motion to change a venue. The court would note that's filed under Criminal Rule 21, which is a transfer of trial. So to be clear, the venue itself of the case does not change, but the location of the trial is what we're talking about, whether or not that should take place in Fremont County or not. And I'm prepared to hear argument on that issue today. So Mr. Pryor, are you ready to present argument in support of the motion? And then I'll ask the state if they're ready to respond on that.
Yes, Judge, and I will be calling my first witness, Mr. Bryan, when the court directs me to start.
All right. Who's going to be arguing in opposition on behalf of the state on this?
Your Honor, the state would, and with due respect to the court, the state does have a standing objection to holding any hearing which may affect the trial rights of Lori Vallow Daybell while her case is stayed and while Mr. Daybell has waived his speedy trial. We understand the court's ruled on that. We're not making a motion, just putting that objection on the record.
Very well. Objection so noted. As we get started here, I do think it is worth pointing out, wouldn't typically ask for something like an opening statement on a motion, but I do want some clarification if I could. I think before we get into argument on the state's position here, because again, there was some talk that maybe the state is either conceding or stipulating that trial should be transferred. However, I'd note in the state's response also, there was a pretty unequivocal statement you've got on paragraph 6, page 5, that says the state asserts that the citizens of Fremont can provide fair and impartial jurors capable of following instructions from the court. So I guess I'd like some clarification on where the state stands on this issue before we get started. Mr. Wood?
Sure. Absolutely, Your Honor. And I would note that the state never said it stipulated or conceded that a transfer trial was necessary. What the state has said is, one, we do believe that a fair and impartial jury can be found in Fremont County. We don't believe that the defendant will be able to meet that burden. Two, however, we do recognize it's a matter of discretion for the court, and as long as the court reasons out that decision should be upheld. What we've said is, in an abundance of caution, in the event that the court decides to transfer trial, we won't object to that if we can follow the code and bus the jurors back in to Fremont County, hold the trial where venue is proper, which I would note is specifically provided for in statute. I'm not making that argument right now, just that's the state's position, that if that's the case, and we certainly don't object to that out of an abundance of caution. But as to whether or not a transfer of trial is necessary, no, we don't believe that it is.
Okay, I appreciate the clarification on that point. So with that in mind, then, that will be a contested motion. So Mr. Pryor, it is your motion. If you'd like to call your first witness, then you may.
Judge, I would call Mr. David Bryan from Ironwood Insights, if the clerk would swear him in.
All right, Mr. Bryan, if you'd please raise your right hand, I'll have the clerk administer the oath.
Solemnly swear or affirm the testimony you will give in the pending cause will be the whole truth and nothing but the truth, so help you God.
I do.
All right, thank you, you can lower your hand. As we get started here, Mr. Pryor, I would ask that you keep in mind the admonishment I gave previously in terms of any specific references that would be particularly inflammatory or otherwise that may further compound this issue. We can do things not off the record, they'll still be on the record, but in a closed portion of this hearing. So I'd ask you to keep that in mind when you're eliciting responses from this witness. And with that in mind, you may inquire.
Mr. Bryant, would you state your name and spell your last name for the record, please, sir?
David Allen Bryant, Bryant.
Mr. Bryant, how are you employed, sir?
I am the Vice President of Analytics at Ironwood Insights Group.
And what is Ironwood Insights Group?
It's a full-service marketing research firm based in Arizona.
Okay, and you were retained to do a survey regarding the Lori Vallow Chad Daybell case. Is that correct?
Correct.
And what steps did you take as part of your process to conduct that survey?
Well, the first thing I did was I did a literature search on media so that I was aware of all of the various names and people associated with this case. I then developed the questionnaire, and that questionnaire was sent to Mark Means. I don't know if he shared it with you or not, Mr. Pryor, but we then received some corrections back on the questionnaire. Once that was approved, we then programmed the questionnaire for both telephone and internet. And we administered that survey between February 15th and February 28th earlier this year in 2021.
Okay, let me talk a little bit about your experience in conducting these sorts of surveys. Can you provide us some background information in terms of your experience in doing these sort of things?
Yes, I have been doing marketing research, survey research, polling research since 1980, when I originally started working for Dr. Richard Worthland, who was Ronald Reagan's pollster. So I've been doing this for over 40 years and analyzing statistics and designing questionnaires and preparing reports based on those survey results.
So you have done this for a significant amount of time, have a significant amount of experience. Is that a fair assessment?
Well, I like to think so, yes, 40 years.
Is there anything that, as part of this survey, that you deviated from in terms of the standards that are put upon people who conduct surveys in your particular business?
No, we adhere to the standards of APOR, the American Association of Public Opinion Research, and the Insights Association. These are standards for maintaining confidentiality of respondents and the way the survey was developed. It's developed to be unbiased in terms of its questions and the sequence of the questions. And so, no, we strove to adhere to the highest standards, which is, in my opinion, the APOR standards, the American Association of Public Opinion Research.
Now, previously, last week, you provided me a copy of the study and the questions. Is that right?
Correct.
And Judge, those questions in that study were submitted to the court as exhibit. I believe it's exhibit number 10. You and I discussed the Ironwood Insights report. We discussed the survey, and the copy you provided to me was a true and accurate copy of the survey that was conducted in this particular case. Is that correct?
Correct.
Judge, I would move for admission of the Ironwood Insights report and survey. That's marked in the booklet that I provided to counsel and to the court and to your clerk as exhibit number 10 in my notebook.
All right.
Your Honor, the state of Jackson would like to ask some questions in aid of objection.
All right, go ahead.
Thank you. Mr. Bryant, I'm not going to get into any of the specific findings of your survey as I ask these questions. but I do have a few questions. You did say that you provided an initial questionnaire to Mark Means and he provided corrections. Is that true?
Yes,
Mr. Bryan, are you familiar with the standards set forth by the Pittsburgh Press Club versus United States case for admitting surveys and polls into evidence?
no,
Okay. Are you aware that when a survey is supposed to be admitted into evidence, that the survey must be conducted independently of the attorneys involved in the litigation?
no,
Okay. I want to ask you a couple other questions. You go to the admissibility. Again, I'm not going to ask you any of the substance of the survey. In your survey, how many counties did you conduct a survey in?
4.
What were those counties?
Bonneville, Fremont, Jefferson, and Madison.
Okay, and what percentage of the people surveyed were in Fremont County?
Judge, we're going beyond the scope of his objection. At this point, he's questioning my
This
witness.
goes directly to admissibility.
All right. And before you jump in, counsel, give me an opportunity if there's an objection. The issue here is admissibility. Exhibit 10's been offered. There's been an objection. Without getting further into cross-examination, which this is becoming, Mr. Wood, what is the grounds for the objection to Exhibit 10?
This poll is irrelevant, Your Honor.
And what's that based on?
This poll is a combination of a survey of Bonneville, Fremont, Jefferson, and Madison County. We are here today for the sole purpose of determining whether or not Fremont County is an appropriate venue. And yet this poll does not provide survey results simply for Fremont County. It's a combined poll. Now, Mr. Bryant may have had a reason at the time to do that. However, we're not here today to determine if Bonneville, Madison, Fremont, and Jefferson combined can provide a fair and impartial jury, just Fremont County. And so where this poll has all these other results from other counties, almost 90% of the results are from other counties. And it's not divvied out by county. This poll is irrelevant this survey and report are irrelevant to today's proceedings.
All right,
Also, this poll does not meet the standards met and Mr. Pryor has not even made an effort to lay the foundation required by Pittsburgh Press Club versus United States. So there's also a foundation objection.
All right, your response to those objections, Mr. Pryor.
Judge, to suggest that I'm supposed to limit my survey to one particular county is ridiculous. And to suggest if he wants to make the argument that because Fremont was only a portion of this survey, that the results are invalid, I'll be dealing that with Mr. Bryant. As far as the Pittsburgh case that he refers to, Judge, the survey, if you read the case, it says that the attorney is involved in the actual polling. The attorney's intimately involved in the case. To suggest that Mr. Means or myself cannot make suggestions to Mr. Bryant in terms of what areas we would like to explore for purposes of a survey is absolutely ridiculous. And Mr. Bryant's going to address those.
All right, there's a pending objection. Counsel, I'm going to take this under advisement for just a minute and review that case. I've seen the case, but I haven't read it recently. So I'm going to take a moment, take a look at that. After I've reviewed that case, I'll come back on and make a ruling on the objection as to foundation. All right, counsel, we'll be back on the record here. The court has considered an objection to the admission of defendants Exhibit 10. The state cited the Pittsburgh Press Club case. Courts reviewed that, which raises the issue of whether or not a survey would be admissible if it is material if it's more probative on an issue than other evidence and has circumstantial guarantees of trustworthiness equivalent to those of the class exceptions they talked about in that case. And then the proponent of admitting that has the burden of establishing the elements of the admissibility. So at this point, the objection was based on relevance and foundation. On the relevance issue, I do find that for purposes of this hearing, there's been a foundation, it's been established that it may be relevant, subject, of course, to cross-examination if Mr. Wood believes there's issues with the way it was conducted. In terms of the foundation, at this point, I would indicate, Mr. Pryor, I don't believe there's been a sufficient foundation laid for the admission of that, but I'll allow additional foundational questions if you have those from your witness before making a final ruling.
Okay. And Mr. Bryant, I want to start again. Can you hear me, sir?
Yes. Can you hear me?
Yes. So at this point, the survey that was conducted by your organization was done in the ordinary course of your business from your company. Is that correct?
Yes.
And nothing deviated from the standard procedures that you applied and the standards that are set out by your trade and organization. Is that correct?
Correct.
And you conducted the survey. Now, in regards to the questions, ultimately, Mr. Means did provide you some suggestions, but ultimately you formatted and put together all the questions yourself through your organization. Is that right?
Yes.
And then those questions were transmitted out on a variety of medium. Is that correct?
Correct. Both. We conducted the survey by telephone and by internet, by an invite to a web survey.
Now, based on the size of this survey, and before we get into that, when we're talking about the percentage of error or the percentage that would apply to a particular survey such as this, how much of a percentage of error or a deviation is there on a survey such as this?
The traditional explanation in a beginning statistics class is you assume that responses are 50-50, 50% said yes to this or 50% said no. So based on that 50-50, we had a total of 177 completed surveys, which yields a sampling error of plus or minus 7.3%. That table is actually included at the end of the report. As you move towards further extremes, as numbers become 60-40, 70-30, 80-20, and so on, then that sampling error becomes smaller and smaller.
Well, that brings up an interesting point, is that part of the questions and part of this survey was to decide and find out what people's feelings were regarding the Chad Daybell, Lori Vallow case, correct?
Yes.
And one of the questions obviously was whether or not people in the survey thought that Mr. Daybell or Ms. Vallow were guilty. Is that correct?
Correct.
And the percentage.
Objection, we're getting into the substance of the poll without it being properly admitted.
I don't need to admit it yet.
Well, if we're going to testify off of it and the results, then it's been offered and we need to get a ruling on the admissibility. So I've allowed for additional foundation. Do you have any additional argument on the objection to the admission of that survey, Mr. Wood?
Yes, Your Honor. There are 7 factors that Pittsburgh requires. So far, Mr. Pryor I do believe he has established Mr. Bryant as an expert. However, he has not met any of the other requirements. In fact, he has, I would argue, actually gone against some of those requirements. And so we still object. He has not laid the proper foundation for this poll or the results to be admitted into court.
All right. At this point, I have considered that objection in light of that Pittsburgh Press Club case. I would note that the question here is not ultimate admissibility at trial for either a jury or a court to consider on the ultimate issue that may go to the results of the survey, as was the case in there. This is a hearing as it relates to argument regarding publicity in a venue motion. And so based on the context of where we are, the court does find that for purposes of this hearing only, the survey will be admissible, of course, subject to cross-examination. Mr. Wood, if you have issue with the way it was conducted. So the court will allow the admission of exhibit number 10, and that will be admitted into the record.
Thank you, Judge. May I continue?
You may.
And Mr. Bryant, so we were on the subject, I'm sorry, I just had a hesitation there. Mr. Bryant, we were on the subject of the survey that was conducted in this particular case. And one of the areas of the survey addressed the issue of whether or not the people who responded to the survey felt that Mr. Daybell or Ms. Vallow were guilty. And can you talk a little bit about the response that you elicited from the survey?
Yes, the specific wording of the question was, and this is question 9, if you were to say you lean one way or the other right now about the guilt or innocence of Lori Vallow Daybell and Chad Daybell, which way would you lean? Now, from the 177 respondents, we had 82.4% said they were guilty.
Okay.
And only one person said they were innocent. We had we had 3.4% said they were innocent until proven guilty, and 11.4% said that they needed more information before they were able to answer the question.
Okay. Now, in applying the margin of error on this particular question, 82%, what is the range of possibility? You had previously discussed that as you get higher up in the level of percentage. Now, we're talking a situation where 8 out of 10 people from Madison, Fremont, Bonneville, and Jefferson County determined 80% of those people in the survey from those particular counties determined that Mr. Daybell and Ms. Vallow were guilty. What's the margin of error? How high could that number actually be, given the margin of error that you would, from your experience, apply in this particular case?
Your Honor, I'm going to object to relevance where, again, this doesn't just apply to Fremont County, and we're dealing with multiple other counties.
Judge, you've already ruled on that. Can I go forward, please?
I'll overrule that objection. Go ahead.
Again, sir, what is the margin of error when we're talking about 8 out of 10 people, more than 8 out of 10 people already determining in this particular district that Mr. Daybell is guilty? What's the margin of error, sir?
5.8%.
So if we apply the 5.8 to the 82 point, what percent?
82.4.
Now my math may be a little off, but I come up with 88% given the high end of the margin of error. Is that fair?
Sure.
Okay. Well,
Close.
5.8 plus 8.4 is
Well, 82.4 plus 5.8, yes.
in north of 88% of the people believing that Mr. Daybell is guilty. Is that fair?
Yes, but it also goes the other way. It goes,
And I'm going to talk about that. It can go the other way as well. It could go down to 77 or 76 point something percent, correct?
correct.
Now, in your experience, and you talked about over 40 years doing this, how often have you run into a poll that was so slanted in one particular direction?
Well, it does occur. If you ask someone how satisfied they are with their new car, 82% might say they're very satisfied with their car. In this case, this is a very large percentage of people who believe that Lori Vallow Daybell and Chad Daybell, well, they lean towards their guilt.
Okay. Now
It's
the
a very high percentage, yes.
So this is, you would consider this a very high percentage.
Yes.
Okay. Now, one of the other questions applied to whether or not Ms. Vallow and Mr. Daybell could get a fair trial, correct?
Correct.
Now, taking into consideration that over 82% believe that Mr. Daybell is guilty, one of the other questions you asked is whether or not he could get a fair trial. What were the responses in regard to that?
Well, we had 22.6% said that they definitely will receive a fair trial in Fremont, Madison, Bonneville, or Jefferson County. And an additional 37.3% said that they probably will, which is a total of 59.9%, almost 60%, or 6 out of 10 respondents felt that they would receive a fair trial in one of those 4 counties.
Okay. So I'm a bit confused. 82% say that he's guilty, but in spite of being guilty, he'll still get a fair trial. Is that what the polling seems to suggest from the folks in Jefferson, Fremont, Madison, and Bonneville County?
Correct.
Okay. Now I want to talk about particulars by way of county, and Mr. Wood brought this up. What are the percentage of respondents from Bonneville County?
55.4% of all the respondents were from Bonneville. Obviously, that's where we were able to get the most respondents.
And obviously that's a significant population in Bonneville County as well, correct?
Correct.
We're talking somewhere around 120,000 plus people, correct?
I can't verify that. Sorry, I didn't verify those numbers before getting on this.
And obviously, if you're talking about Boise, you're talking about a market it's not as big of a market as you would find 500,000 people in the Boise market, correct?
Well, that's correct.
Objection assumes facts, not in evidence.
Sustained. I'll strike that answer.
Okay. So at this point, what were the percentage of Fremont County?
We were only able to obtain 10.2% of our 177 respondents. So about 18 people were from Fremont County.
Does that change your factors in terms of the margin of error any?
Well, not on the overall survey responses of 177, no, but if we had to just analyze the 18 people in Fremont County, yes, it would create very large sampling errors.
Right, right. So the idea is not just to limit yourself to Fremont County. The idea is to get an overbroad spectrum of people from a variety of areas to get a more accurate polling of what people's beliefs are. Would that be fair?
Yes.
Okay, so what did we do in Jefferson County? How many people over there?
Well, we received 15.8%, about almost 16% of our 177 are there in Jefferson County.
And then how about Madison County?
18.6%.
Okay, so the people as a result of this survey were predominantly from Bonneville County, is that correct?
Correct. Well,
And
over 50% from
Right.
all 4 counties came from that one county.
Right. So predominantly the idea here, and obviously you're the expert in this, is to draw from a large swath of people to get a more accurate representation of how people in Eastern Idaho feel about Mr. Daybell and Ms. Vallow. Would that be fair?
Well, that was the objective, yes, to collect information from all 4 of those counties.
And the cumulative information only provides at 80%, all of the cumulative counties and the information that was obtained provides a margin of error of just a little over 5% then, is that correct?
Well, on that one question where it's 82% who said yes, they leaned towards the defendants being guilty.
Right, okay. Judge, I don't have any further questions. I'll defer to counsel at this point.
All right, Mr. Wood, cross-examination.
Thank you, Your Honor. Mr. Bryant, thanks for being here. I want to talk about the universe you chose to conduct your poll. You did state, correct, that your participants needed to be at least 18 years of age, and either have a valid driver's license or be a registered voter in Idaho living in Bonneville, Fremont, Jefferson, or Madison counties, correct?
Correct.
And you did that to make sure that the people you polled were potential jurors, correct?
Correct.
Okay. Now, I want to talk about, you said Mr. Means gave you suggestions on questions.
Yes, I wrote the question, and I have to tell you, thank you for asking that. The one big change that Mr. Means gave is he wanted to make sure that the word Vallow was included in Lori Vallow Daybell's name.
Okay, but so he did participate at some level in the creation of the questions.
Yes, I did not include Vallow in Lori Daybell's name.
And did he make any other suggestions to you?
I don't recall that he did, no.
Okay. I want to talk about your representative sample. You've said that 10.2% of the individuals polled came from Fremont County, correct?
Correct. And
And
that,
that, according to my math, is about 18 people. Is that correct?
yes, I actually have the numbers right here. Actual numbers, if you don't mind.
That would be great.
We actually have achieved 98 out of Bonneville, 18 out of Fremont, 28 out of Jefferson, and 33 out of Madison. I can repeat those if you need me to.
I've got it. Thank you. You've been conducting surveys and polls for, you said, approximately 40 years.
Correct.
How many times have you polled as to the guilt of a criminal defendant in an area where a juror could be called?
Twice before.
Twice before. So this isn't done regularly, is it?
No, I have to admit, most of my research is in healthcare, public policy.
Okay. And so in doing your poll, let me ask you this. Are you familiar with, did you study any census numbers to get the relative populations of the counties you polled?
No,
Okay. And you said that you sent an invite out for the poll online. Is that accurate?
correct.
And so, and how did people respond to that? What was the methodology for sending that out, and how did people respond to it?
We contract with a sampling firm, specifically Dynata, which is one of the largest in the United States. They're based out of Provo, Utah. And Dynata, we requested panel sample meeting. We identified the criteria of over a certain age, driver's license, registered voter in those 4 counties. They told us how many they had where they had email addresses, and they told us how many they would have where they had telephone numbers. So when they had email addresses, we sent them an invite indicating that we were conducting a poll with residents in those 4 counties. And if we were able to get a response by web via an online survey, then we collected those. If we had both an email address and a telephone number, and they did not respond to the web invite, we then followed up with a telephone call. If all we had was a telephone number, then we started out conducting by making telephone calls.
Okay. In the email that was sent out, did it identify what the subject of the poll was?
Yes,
Okay. So someone who is interested in that issue might be more likely to take that poll, correct?
that's correct.
Okay.
I mean, we did not say it was a murder trial in eastern Idaho. We just said we're interested in your opinion about a local a court case that you may or may not have heard of.
Okay, so it didn't identify it by the words Vallow or Daybell?
No,
Okay. All right. So let's get to, we're here today, Mr. Bryant, to determine if jurors in Fremont County are able to be unbiased in a jury trial. And so as I look at your poll, I cannot read this and get information specifically about jurors in Fremont County, correct?
that is correct. Because we were I'm sorry to interrupt, but we were requested specifically by Mr. Means to conduct the survey in all 4 counties.
All right. And he did not request that you divvy that up county by county, correct?
That's correct.
Okay. And so if I want to know, if I want to poll and survey potential jurors in Fremont County, well, strike that. Did you do any type of county to county comparison in the numbers you received?
No, I was not requested to do that.
Okay. And I think you testified earlier, you're not familiar with the population size of Fremont County, correct?
Correct.
Okay. Really quick, was this poll conducted, do you know if it was conducted on behalf of Lori Vallow Daybell or Lori Vallow Daybell and Chad Daybell?
Wow, my understanding is that it was being conducted on behalf of both.
Okay.
That's my understanding.
Okay. And when you asked the questions in your poll about guilt, say question 9, you didn't separate Lori Vallow and Chad Daybell, did you?
No,
So again, and sorry, I kind of got off on a little bit of a tangent there, but if I want to, again, I can't look at this poll and know and separate information about Fremont County without it being combined with information from those other 3 counties.
well, I could do that, but given that we only have 18 respondents from that county, your sampling error is going to be huge. And I usually, as a rule of thumb, we don't put forth results for just anything under 25 respondents. And with only 18 in that particular county, the numbers would have very large sampling errors.
Okay. And so would you agree with me that 18 individuals is a very small amount of individuals to poll on an issue like this?
Well, if I'm looking at just that one particular county, yes, but the objectives that were given to us from the research specifications were not to just survey just one county.
Sure, and I understand that. And the questions I'm asking are not necessarily what you were asked to do. We understand you were given a commission and then you followed that commission. I'm not questioning that. It's the applicability to Fremont County. And
well, with only 18 respondents, I would not apply the results from those 18 respondents to reflect the entire opinion of residents in Fremont County.
thank you. I have just a couple more quick questions. I would note that your question 1, it reads, are you familiar with any crimes that happened in the Rexburg area over the last couple of years where 2 or more people were killed? That's the question, correct?
Yes,
And you would agree, would you not, that the moment you say the word crime, you imply that someone's guilty, correct? Because crimes don't commit themselves.
well, you're getting into semantics here, Mr. Wood. I guess
Okay.
that's the language I put in the questionnaire, and
Okay.
nobody objected.
Did you ever ask anybody if they believed that individuals are entitled to a presumption of innocence before proven guilty?
No, that was not the objective. However, we did have that as a response category that had been assigned to question 9. When you're reading just for clarification, when you're doing a web survey, these were all what we call closed-ended questions. And so when someone saw the question 9, if you were to say you lean one way or the other about the guilt or innocence of Lori Vallow Daybell and Chad Daybell, which way would you lean? All the respondents saw the possible responses of guilty, innocent, innocent until proven guilty, and need more information before answering. And they had the option of saying, I don't know. So they saw those on the screen as they were conducting the survey. Similarly, if they participated in the survey via the telephone, the interviewer read those response categories to the respondent. And so there again, they heard the words innocent until proven guilty.
Okay.
Did that answer your question?
Somewhat.
Not exactly.
I understand a little more how the poll was conducted now. Based on the way these questions were asked, would you be able to separate out the bias against Chad Daybell as opposed to Lori Vallow Daybell?
No,
Okay.
I'm sorry. Yeah, the only thing that gets to that is we have, we have questions 3 and 4. Question 3, do you remember any details about this crime or the people involved? That was an open-ended question. So we didn't give them any names, but, and so you can see in question 3, 39.2% mentioned Lori Vallow Daybell, 35.2% mentioned Chad Daybell. Those are what we call open-ended questions. I didn't give them a list of options to select from. People mentioned Lori Vallow Daybell or Chad Daybell.
Okay. Now, based on your answer that you can't separate the bias totally between Mr. Daybell and Mrs. Vallow Daybell, is it also fair to say you cannot separate the bias between Mr. Daybell and Mrs. Vallow Daybell in Fremont County?
Oh, definitely not. Not from only 18 respondents, no.
So, Mr. Bryant, with the way you're answering these questions, if you were to conduct a poll for the purposes of finding if a jury could be pulled in Fremont County only, you would have wanted to question a lot more than 18 people, correct?
Well, I would have, yes. Statistical rigor, rules of APOR would have requested or would require that we had at least 100 completes just from that one county.
Okay. I just have just a couple more questions. Did you have any help in conducting the survey from people in your firm?
Absolutely, yes. I had a project manager. I had programmers who programmed the survey.
And would you consider those people that work with you to be experts?
Well, absolutely.
Okay, that suffices. I don't.
Yes.
Were you aware of the purpose of the litigation when you conducted your poll?
It was originally mentioned to us by Mr. Means that yes, this was specifically the Fremont change of venue survey.
Okay. And again, you testified earlier that you're not familiar with the United States Supreme Court case, Pittsburgh Press Club versus United States.
Judge,
No.
I'm going to object at this point. This court made a ruling on that issue, and Mr. Wood is just trying to relitigate an issue that this court already addressed.
Your Honor, I'm entitled to ask questions that go to the weight of the survey.
I'm making a ruling already, Mr. Wood. It's overruled. I think it is still relevant, so you can answer the question or you can re-ask it, Mr. Wood.
No, he did answer the question, if I'm correct, that he was aware of the purpose of the litigation, Your Honor.
And the
The
question
state this time has,
Mr. Wood, the question objected to is about the press club opinion. And I don't believe it was an answer.
well, he already testified to that, Your Honor. He wasn't aware of it. That's fine. At this time, the state has no further questions for Mr. Bryant. The state would make a second motion to exclude, though, based on Mr. Bryant's answers, that this poll for the purposes of Fremont County is simply not sufficient. I think he said he need 100 complete surveys. And there are only 18. So again, the state makes a second motion based on lack of relevance to exclude this poll.
All right, your response to that motion before we get into further redirect, Mr.
Yeah.
Pryor.
Judge, at this point, the survey was done in a 4-county area that included Fremont County. As a whole, and as a complete whole of 170 plus 77 responses, Mr. Bryan testified that the margin of error is 5.8%. So as a whole, in counties that include Fremont, in counties that include Madison, in counties that include Jefferson and Bonneville. Now, the allegations in this case are rise out of both Madison and Fremont County. To have this court order myself or Mr. Means to do a survey in Fremont, then do a survey in Madison, then do a survey in Jefferson, and then do a survey in Bonneville would be prohibitive. So my feeling is if the court wants to apply whatever weight to this survey it wants to apply, that's the court's prerogative. And at this point, the relevant argument is inapplicable in this particular situation. It's clearly relevant.
All right, I've considered the state's second motion to exclude after the testimony of Mr. Bryant. The issue that's brought up for the court is the small number of Fremont County citizens that were polled as part of this polling, a total of 18. The issue before the court is whether or not a fair and impartial jury can be found within Fremont County. And for purposes of this hearing, which is what the Exhibit 10 is being proffered for, and the issue as it relates exclusively to Fremont County, the court does find, based on the responses of Mr. Bryant, that Exhibit 10 will not be considered both for lacking foundation and on relevance grounds, mostly based on his very candid testimony that he would not apply the results of the survey to Fremont County because the sampling error was too small and the margin of error would be potentially too large, and it would go against the standards of APOR, which are the standards he used to conduct the survey with a result of only 18 participants on the survey. So I think clearly, having heard those responses, the court can't consider this survey as it relates to finding potential jurors in Fremont County. So the court is going to sustain that motion offered by Mr. Wood, and the survey Exhibit 10, although previously admitted, will not be considered in the court's determination on the issue.
And Judge, in response to the court, if I may, if you look at my change of venue motion, I am asking to move from Fremont County, but I specifically in my motion address the issue as it relates to the 7th Judicial District that includes Madison, Jefferson, and Bonneville counties. My motion for change of venue specifically says that this hearing and this trial could not be effectively held in the 7th Judicial District. So I would ask the court to strongly reconsider its position as, although this is Fremont County, I think the court is splitting hairs by saying, yes, Fremont County, and but frankly, I was also moving for the entire move from the 7th Judicial District. And under the rule, I'm permitted to seek a change from a particular judicial district. So at that point, based on how I've pled this in my pleadings, I think it is relevant.
Your Honor, I would just very quickly respond. This poll did not include all of the 7th Judicial District. It left out Bingham County, which is a fairly large county, and a couple of other smaller counties. So the poll would still not be relevant.
Well, Judge, you know, I don't have to go over every entire county to do this. What I do is I take the largest county within the 7th Judicial District, who happens to be Bonneville. I take the 2 counties that happen to be where a significant number of these allegations arise, and I take the adjoining Jefferson County. So when I pled this, I included the 7th Judicial District in my pleadings, and under the rule for a change of venue, a transfer, a trial, I am allowed to select and plead that this particular judicial district is not appropriate. So I renew my motion, Judge, and ask the court to reconsider and allow this exhibit to be admitted.
All right. Well, I've considered the arguments on the admissibility of this Exhibit 10. I've also considered the change of venue motion itself and Criminal Rule 21. And still the question before the court today, while Rule 21 does contemplate whether transfers should occur within the district or outside of the district, and that's part of a determination, the first question the court has to cross as a threshold before getting there is whether or not we are transferring this trial out of the current location of Fremont County. And so the issue is whether or not we could find a fair and impartial jury in Fremont County. We haven't made a determination yet that it's being transferred within the district. If it were there, potentially this would be admissible, but where we are right now is trial located in Fremont County. The first judicial question I have to get to is whether or not we're going to go outside of Fremont County, and then we'd consider where an appropriate place would be, a different county. And so based on consideration of all that, still with those responses we have and only 18 people polled within Fremont County, the court's not going to change the decision I've made that Exhibit 10 will not be admitted or considered for purposes of this motion today. So that'll be my ruling, counsel.
And Judge, I guess in my position, simply if the court is excluding the report for purposes of Fremont County, at such time, if the court decides that Fremont County is not appropriate and is looking at whether or not the 7th Judicial District is relevant, at that point, this report does become relevant at that point.
Well, that is a potential, Mr. Pryor, because under Criminal Rule 21C, under Parts 1 and 2, there may be a determination made as to whether it should stay within the 7th District or without. And I would reconsider the ruling if we were looking at potentially moving within the district. So for purposes of where we're at today, I'm not considering it, but your point's well taken there.
All right, and Judge, so at this point, I would reserve my ability to seek a motion from the court asking that the court apply Mr. Bryant's report in the event the court moves this case from Fremont County, and it has to, at that point, under the rule, consider an appropriate judicial district.
All right, I'll just take that request under advisement at this time, depending on where we end up. So,
and I have nothing else for Mr. Bryant, Judge.
Okay, thank you, Mr. Bryant. Then that'll conclude your testimony this morning.
Thank you. I'm free to leave the Zoom meeting.
You are. You can log off.
Thank you, Judge.
Thank you. All right, do you have another witness to call, Mr. Pryor?
I don't have witnesses, Judge, but this may be an opportune time to have a meeting to discuss my notebook and how I would present the remaining exhibits in a way that complies with the court's admonishment about unnecessary advertising. So I would like to have a brief discussion about how I intend to proceed with the remaining documents and then go forward from there if the court would accommodate that request.
All right, I think that that's a reasonable request. I think the time's good for that as well.
You know, I would ask though if we could take a brief 5 to 10 minute break before that.
Okay, so here's what we'll do. We'll take a break until 10:30, at which time I'll ask the clerk to please set up a breakout room where I'll meet privately with counsel. I will have the court reporter take a record of the proceedings of the breakout room, and we'll discuss potential exhibits to be admitted in furtherance of the motion. So we'll be in recess for 10 minutes, and then we'll reconvene in the breakout room.
Thank you.
You're welcome.